friends and family. I'm Susan Russell, president of Our Legacy Plus. Legacy is something that is handed down or conveyed from one person to another. The legacy you leave is the residual of a life well lived. Our Legacy Plus is designed to help you on that journey. My Fireside team today is Ms. Naja Howard, president of Young Men Strong, Dr. Sonia Smith, president of Family Matters, Dwayne and Chanel Hall, presidents of Couples in Business, and Ms. Winnie Benjamin, president of Stewardship Masters International and a certified business coach on the John Maxwell team. Today, we are excited about our special guest, attorney Abdul Rahman. And let me tell you a little bit about him. Mr. Rahman has operated his law firm since 2004 with an emphasis on real estate, business law, and family estates. He is an active advocate for community development and generational wealth through property ownership. He represents real estate investors and developers, and many of the clients are first-time homebuyers and entrepreneurs in the New York City metropolitan area. Mr. Rahman teaches courses in business law and ethics at CUNY, York College, and he serves on the board of directors for the Family Boulevard Community Development Corp. He obtained his undergraduate degree in finance from Howard University in '98 and earned his law degree from Howard in 2003. Our moderator today for our Fireside Chat is Miss Winnie Benjamin. Okay, Winnie, I'm turning the mic over to you.
Thank you, Susan. Thank you, and welcome one and all on our Facebook page. And of course, right here in our studio audience, we have nothing else but in my opinion, a decorated team of professionals. And I'm really excited about this. Susan, thank you so much once more. Each week, we have to thank you for the opportunity to share your platform and to ask questions and to discuss in our fireside chats. The program for today is so powerful because, as I know, Susan, your passion is having families actually maintain sustainable legacy from generation to generation. And we understand that an asset portfolio made up of money, gold or real estate does not necessarily, allow a legacy to continue. We know it's the relationship you have between father, mother, children, and the siblings among themselves. We understand that health is important because an entire family could die early. We understand that that inner connection to the spiritual, to God himself, allows us to make good, sound, moral decisions that will not torpedo what has been worked hard for. And just being mindful of the moment so we don't make the mistakes that's unnecessary. All together working allow the physical assets to manifest. That has been your talk for a year. We have been working together. And it just gives me such great pleasure to see that the team that came together to support that, because they operate in their own rights with the desire for legacy, is Dwayne and Chanel Hall. They're my clients, I'm proud of them. And they are working feverishly to see that Black families, or they say melanated families, I believe that's right, to build wealth and have large communities of melanated wealth. I know that's their journey. That's through the mission that they're doing in building solid couples that supports your vision of legacy. We have the awesome, well-known, I would say almost worldwide now, Naja, who has for 20 years been on this journey of helping to support families. In her, what has happened with her is that she is a single mother raising a wonderful young man, and this is not by desire, is not what she wanted, but we know that it happens, and what her passion is to help to contribute betterness in the world by doing the best that she knew how and teaching other women that if they fall, unfortunately, in the situation that she's in, how to bring their children back in good behavior, moral upbringing, so that they too could start a good family and follow on this wagon going forward. We have Dr. Sonia Smith for over 20 plus years. She has been working with families, and she calls them, they all come together with their suitcases, husband and wife, they come together with their suitcases of problems, and she has been able to have them push through the foolishness and the adversity into a much more holistic growth in the family, so it impacts their children, so that their children too will continue to build a holistic legacy. So in each of the businesses represent here, no matter in the way they do it, is all to support that vision of our legacy plus. And so that's why I believe Esau knows that vision. I've heard him for years, and in maybe not in the same direct way that I'm saying it, but the essence is the same. He's very concerned about families holding on their legacy. And so for that reason is why he's here.
The doorbell.
So based on that, I would then say, welcome, welcome, welcome.
Thank you.
Esau, Abdul.
Yeah, you caught me in the middle of my thing.
Did we mute you? Wait a minute. We're not hearing you.
There you go. Sorry. Thank you very much,
Okay.
Mr. Winnie, for that wonderful introduction. Thank you to all of the Fireside Chat members on the panel today. And thank you to Sister Susan, Ms. Russell, for her vision in pulling this together. You know, I think that what she is doing with our Legacy Plus, is really the first point in the few points that I have to get our conversation started today. So again, my name is Abdul Rahman. I am an attorney based here in Queens, New York, for the past 17 years, by the grace of God. Myself, my family's here in Jamaica. My wife is also a licensed clinical social worker, similar to Dr. Sonia. Is involved in a lot of the work that our panelists have been speaking about already or have touched on. So I'm going to be brief in my opening remarks, and then we'll dive into our conversation. 3 C's. 3 C's is what I'm sharing. 3 C's of continuity. So continuity is really what we're talking about. And I just want to highlight 3 C's that go into this notion of continuity. And the reason I'm saying continuity is that, we're talking about legacy, right? And legacy implies the continuation of something of value, right? So that's continuity. But how do we produce continuity, especially within a family and then within a community? How do we produce that continuity? Well, the first C in continuity is communication, right? We have to be talking about the things that we value. We have to be pointing out the things that are corrosive or unhealthy. All of these things we have to talk about. And I won't, try to be the LCSW today. I'll leave that to the professionals. But, we know that communication, when it's stifled, so many of the things that we do value also become suffocated. So we have to communicate. That's C number 1. And I think that with what Sister Susan is doing with this platform, our Legacy Plus, she is catalyzing communication, right? Setting an example, setting the trend, and sparking the conversations so that, we in our families, in our households, in our communities can proceed with that communication. C number 2 is culture, right? So, and it's very, I'm kind of I won't say a student of culture, but definitely an observer. And you notice that, there are different groups of people that can become very proficient at different things. One group of people is excellent at home building. Another group of people is just excellent in the culinary department. But part of that is because the proficiency gets translated or transferred from generation to generation as part of the culture. It's as part of the culture. Sometimes I wonder, it's funny. I passed by. It was, I guess it was a bodega on the way. I guess I was maybe coming home or wherever I was going the other day, and there was a mother holding a small child. She might have been pregnant herself. The mother already had one child in her arms. She might have been pregnant, but it was early in the morning, and she was lifting up the roll gate to the storefront of this bodega. And by the time the roll gate got to about shoulder height on this mother, who literally had the child in one arm and lifting a roll gate, an iron roll gate in the other arm, or aluminum, the little child that was in her arm put her hand on the bottom of the roll gate and started pushing it up along with mommy. And I'm like, okay, wow, look at that. Look at that. That's part of the culture, meaning, mom was involving the child in this daily routine of opening the store, to the point where the little child recognized that, okay, mommy's lifting the roll gate. I want to help mommy. I'm going to put my hand on the roll gate and help push it up also. Part of the culture, right? But when we're not communicating about the things that we're doing, the decisions that we're making in our finances and our investments, if we're not communicating with one another or with our kids about those things, then it can't become part of the culture. It just becomes a secret thing that mom is doing, or that dad is doing, or mom and dad are doing, because nobody really knows what's going on. So we have to communicate and get past some of the apprehension about having our private business be known. Yes, I'm sure discretion is needed, but communication contributes to the culture. And then with the culture, now here's the part where Issa tends to come in more so, you have to have the contract, right? That's the third C of continuity. It's good to have the communication, you need it. We have to develop the culture, necessary. But if we don't document it, if we don't put it on paper with the proper documents, with a trust, with the will, with an LLC, whatever the case may be, but if we don't have the proper contracts in place, then it's very difficult to attain that continuity, right? So as we talk about, and as we get into our discussion today about legacy, I just wanted to share those 3 C's, which I think are part and parcel to establishing and fostering continuity: communication, culture, and then getting it down on paper in the correct forms of contract.
To unmute myself. That is awesome. And I don't know if you realize, when you did the first C1, did you see the great smile on Dwayne and Chanel's face? Because on the 10th, they are going to be doing a launching of their business, and their entire focus of their program and their training for couples going to be all around communication. So I'm going to open, before I ask my question, does anyone want to ask Isar about any of those 3s? So chiming on the communication, or any questions that you want as it pertains to legacy, even developing trust. I have my tons of questions.
Yes, I do have a question.
Okay.
I do have a question. It's nice to meet you. My first question, I guess, would be, what is the difference between a will and a trust?
Excellent question, and a great place to start. So the main difference is that with a will, the assets of the testator is what is called. The testator is the one who is writing the will, or the one on whose behalf the will is being written. So with a will, the property that is owned by the testator does not get transferred to anyone until the testator passes and until the will has been probated. What that involves, it's a court process, here in New York and basically any state in the United States. The will has to be authenticated by a court of law before the named executor will have any legal authority to manage or handle the assets that are included within that estate. So
Wow.
the will, all of your property, it stays in your name. When you die, the will has to go through court, through probate, to be authenticated. Then the executor has the authority to manage, sell, whatever, the properties that you left in your name. Now, with the trust, the difference is you take property out of your name while you're living, and you retitle the ownership of those properties or those assets in the name of the trust. So the trust becomes the owner while you're still living. Now, when you pass, the trust acts similarly to a will in that the properties can go to the named beneficiaries in the trust. But what's interesting about the trust is that the properties don't really have to go directly to the beneficiaries. You can retain them within the trust until certain conditions are met or under certain conditions. So the trust has a little more flexibility, well, a lot more flexibility than a will to preserve a certain measure of continuity. So I can give examples, but I don't want to eat up all of our time with the examples.
And I just want to say, so it sounds like the trust would be a better tool if you want to minimize or even avoid paying an inheritance tax.
Not necessarily. No. Well, the short answer is no. The inheritance tax is not avoided by the trust. What gets avoided by the trust is the probate court. That's what gets avoided by the trust. And then whatever fees go along with, having to probate a will. The inheritance tax is still going to, well, and I don't want to get too technical because inheritance tax nowadays, it only applies once the value of the assets that are being inherited exceed, roughly $5 million. So right now, a lot of our households are not going to deal with inheritance tax at all. But as we do get into those levels, once you're inheriting, period, whether it's through the will or through the trust, some level of inheritance tax is still going to be applicable.
I just have one question. When should someone set up a trust? I know the average, melanated family don't really have a lot of financial wealth. So maybe a lot of times we might not see the importance of setting up a trust. So when would you recommend that it would be financially feasible or necessary for someone to set up a trust?
Good question. And the answer that you're going to get from me and a lot of attorneys with a lot of questions is always going to be, it depends, right? So that's usually the main answer. But to kind of give my opinion of general good practice, I think that if you're in good health, then by the time you're getting into your 50s, you should be looking at doing the trust. And that's for a couple of reasons. And 50s is on the young side, right? But I'm giving, just a general reference point for a time when people should really think about it seriously. The most common usage of the trust in my own practice, right? And I can't speak for every other practitioner, but in my own practice, the most common use of the trust is for Medicaid planning. And basically what that means is if you spent, a good chunk of your life building up, your assets, and you own many of them, they might be in your name, or even if they're in LLCs, then you might technically be the sole member, or you and your wife members of the LLC. So those are still your assets, still your property. If the need should arise where in your long-term care, you have to begin paying for expenses that your insurance doesn't cover or Medicare doesn't cover, then a lot of our elders want to be in a position, and their family members want to be in a position where Medicaid can cover the long-term care. But if Medicaid starts paying for anything, Medicaid is going to want to be reimbursed against whatever assets you own. And so what we try to do is, if you anticipate the need for long-term care of that nature, then you take assets out of your name so that once Medicaid pays for the healthcare services, they don't have anything to go back and recapture or be reimbursed against, because those assets have been moved out and placed into trust. As many of you already know, the goal is to do that at least 5 years prior to the need arising, because Medicaid has a look back period. And so again, 50s is young, right? But if you reach 55 and you're in good health, start thinking about it. If you advance, on into 60 and still in good health, think about it nonetheless, because a lot of times our health, or the health of our elders, can, begin to shift pretty quickly. And a lot of times we don't anticipate that, and that 5-year window becomes problematic. I'm speaking it, from having assisted a number of clients in that situation. So I would say in your 50s, 55, 60, be thinking about a trust if you're in good health. But if you're younger than that and your health is, beginning to show some signs of concern, start thinking about doing the trust.
Now, may I chime in here for a quick second? I was told that there are various or a number of forms of trust, if that's the right word I'm putting. One's called revocable and irrevocable. That's one. And I have seen, because I have a friend whose property is in a trust, but she is currently the executor of the same trust, where she can still write bills and everything, from the position of a trust. What do you say or recommend, the pros and cons on that?
Okay, excellent question. Again, the short answer is it depends. The longer answer, let me just clarify those two things. The revocable and irrevocable trust. So a revocable trust is what it sounds like, right? It means you can create the trust and you can place property or assets into the trust. But if you change your mind and you want to, change some things about it or take some properties out of it while you're still living, you can do that. You can revoke the trust or revoke certain provisions of the trust if it's a revocable trust. If it's irrevocable, essentially that means that once you set it up, you can't change it. That's, for all intents and purposes, that's what it means. There are certain limited exceptions to that, but we don't need to get into that right now. So the idea is that you can't change it. For Medicaid purposes, again, which is the main reason why most of my clients will deal with the trust, you can only do irrevocable. And the reason for that is that Medicaid wants to know that you don't have assets that you still can control. If you still can control it, then you still can pay for the nursing home, right? That's how Medicaid looks at it.
Yeah.
So Medicaid will only, I guess, accept an irrevocable trust. And just as a point of clarification, so once the person who sets up the trust or whose property is being placed in trust is referred to as the trustor, or maybe the settlor or the grantor, right? The person who is being entrusted with the management of those things is referred to as the trustee, right? That's the trustee, not the executor. The executor is under a will. Under a trust, that person is called a trustee. And in some cases, the grantor, who is the person setting up the trust, can also be the trustee, which is what Ms. Winnie just described. The grantor was also the trustee, and that is allowed, but for Medicaid purposes, that would not be advisable, because Medicaid would look at that as, okay, well, it's still your stuff, so pay up.
So are you saying that even if it's in an irrevocable position, you, the grantor, could still be the trustee in the irrevocable position? Or
legally, yes, but for practical purposes, for Medicaid planning purposes, no.
Should not be.
We don't do that, right?
Got you. Okay. So I'm giving the floor to someone else. Nija.
Hey, brother. So I do have a question. It's kind of a personal one. I'm hoping that the listeners can relate to it, but I've recently entrusted or became the trustee of several properties. one of the homes that I've been, oh, I'm so sorry. One of the homes has a reverse mortgage. I'm curious to know, how do I own that property if it has a reverse mortgage on it after the grantor passes on?
Good question. And reverse mortgages, I guess, let me just touch on that briefly for the audience and the listeners. A reverse mortgage is similar to what it sounds like. It's a mortgage where you're not making monthly payments, but instead, in some cases, the bank itself is making monthly payments to you if it's set up that way. Or the bank has a lien on the property that does not require you to make monthly payments. You can just stay there, rent free, so to speak. But what happens is that the balance of that mortgage goes up each year that you're still remaining in the property. So instead of it going down, in the reverse, it goes up. So that's a reverse mortgage. It's only available to homeowners who are at least 62 years of age or older. And the caveat with the reverse mortgage is that once that homeowner is no longer living in the home, then the entire mortgage becomes due immediately. And they give you a little grace period, but it becomes due immediately.
How long is the grace period? Is that 6 months to a year? That's what I'm hearing. Or what's the?
No, it's usually 90 days for them. 90 days for you to tell them what your plan is for either refinancing the property or selling the property. And then depending on what your plan is, they'll work with you on a schedule of how quickly that has to happen. But it's not a lot of time. It's definitely not a lot of time. So they're, generally speaking, once the borrower, the reverse mortgage owner, is no longer living in the home, the bank wants their money and they want it pretty quickly. In some situations where the borrower is deceased, but that borrower left a surviving spouse who is still in the home, then in those situations, the reverse mortgage company can allow for the non-borrowing spouse to continue living in the property. And then when he or she passes, then the bank will resume its collection activity. But if there is no non-borrowing spouse that's still living in the property, then chances are the bank is going to want to be repaid. And then it depends at that point on the value of the property. If the balance of the mortgage exceeds 95% of the appraised value of the property, then the bank is willing to accept 95% of the appraised value if you're selling it. And if you're going to refinance it, then you have to make sure, you or whoever is going to be doing the new mortgage have to make sure that the numbers make sense to do that. And a lot of times the numbers don't make sense.
Oh, yeah. Oh, that's so sad.
Yeah.
Okay.
So this is all good information if we are planning to maintain this legacy continuity. Okay, that's what we are talking about. For those who just pop in the middle of the conversation, we are talking about continuity, the processes of continuity to ensure that the legacy that you work so hard and desire to develop continue. We have with us, of course, Abdul Rahman, Esquire, and he is talking some heavy stuff that I believe, like you said, the melanated families, all families, but mostly the melanated families need to understand that process so that, not that we don't want attorneys to get rich, okay, but most attorneys are getting very rich over the ignorance of our people fighting over estates, and some of it is some of these businesses and our real estate's been locked up and locked down in our communities for years because siblings are still fighting and cannot make a decision. I don't know how long a court will permit for real estate within a community as public domain, when I should say the government still has some jurisdiction. I don't know, but it's sad when we see Brother Issa, so many good real estate. It's just locked down for years. and you're in a corridor where there are such existing, and we don't know what the reasons are or how it becomes that way, where it's permitted to be locked down for so long and it's not adding value to the community. Do you care to add to that in any way?
Sure, sure. Interesting, interesting note that you raised. That probably can be a topic for a whole separate fireside. But you all know that real estate is a very useful asset for a lot of different reasons. Real estate can be housing, it can be a location for business, it can be rental income. But it can also be for tax write-off purposes, right? When the property is being operated at habitual loss, real estate is used for depreciation expense. Is used for, again, operating losses. So sometimes people will own properties, even commercial properties in our communities, and just hold it because it helps them to offset the high income that they earn as a doctor, as a registered nurse, as a this, as a that, right? So it becomes challenging. Yes, we strive to be high income earners, but as many of you know, Uncle Sam, and his cousin, New York State, they want their cut. Taxes eat into every. So you work so hard in your education and your career, and you get far along, and you're earning a nice income. You don't want to see so much of that income go to taxes, and so, but there's only but so much mortgage interest that you can use to offset your taxable income from a primary residence. And so you say, all right, well, let me get another property, and then that will take you so far, and then you say, well, let me get something commercial and let me just let it sit so I can, the value of the asset goes up, because real estate value is always going to go up over time. But as far as your taxes are concerned, you're able to start depreciating things and writing off operating losses. So that's part of why we see some of what we see within the community. But like you pointed out, Winnie, another part is really stems from lack of communication and culture. Some and as an attorney, I'm never one to really tell someone what I think they should do. I just try to, unless the situation calls for that. But generally speaking, I had a client that called and said, all right, well, my family owns a property in St. Albans or wherever it was. There's 4 of us, 4 surviving siblings. My mother was the last to pass. 1 sibling lives in the home, let's say. And, what should we do with the house? Like, well, why are you asking me? But I mean, I'm partly kidding. Yes, you want to get input from trusted advisors. So I'm happy to offer. And what we ended up doing was just, an evaluation of what the different options could look like. So I'm happy to do that with clients that are in a situation where they are trying to figure out what they should do. But I halfway joking in the sense of part of what we need to do is to say, hey, well, here's what we think we would like to do, but tell us if you think that that's advisable, or if there's a better way to approach it, or something that might be different. But it's not good to not have an idea of what you want to do, because that's how you waste assets, right? If you don't know what you want to do with it, then it will be wasted eventually.
Wow.
So in that case, what could they have planned ahead of time so that at the death of the head, the mother, whatever, the children don't fight over the assets? What could she have set up before that happened?
Right. Well, I mean, I know we say fighting, but I would say if it's a pie of 100%, I would say maybe 30% is fighting, 70% is not having a vision and not having a particular plan. Fighting happens, yes, it does happen, but it's not the majority of the time. The majority of the time is mom and dad, they worked hard and they had something in mind, but we don't, we, the surviving children, we don't really know what that has to do with us. We have, we have our own lives, we have our own kids, we have our own houses, we have our own obligations, we have our own this. And so there's no understanding of, well, what, aside from the cash value of what mom and dad did, what else are we supposed to do with their stuff, So without having a particular, and there's, in one sense, I would say there's nothing wrong with that, right? In one sense. Again, I'm not here to judge anybody's, particular plan.
No, I'm trying to figure out what could the mother have set up ahead of time before she passed, so that the family member who's living in the house, who probably wants to stay there, doesn't have to fight with the other family members who would like you to sell it, divvy it up, and give them their share.
Well, the first part starts with intention, right? When we do wills and when we probate wills, the main, I guess, lens through which a will is viewed is what was the testator's intent, right? Intent. That's where it all begins. And so, I know, and a lot of times we kind of jump to the third C, which is the contract. What could be set up? What could be drawn up? What could be written up? So, well, I could write up just about anything imaginable, but if the person does not have intent, I can't make it up for them, right? I can write it up, but I can't make it up. So they have to have an intent. So if mom had intended for, I have, another person, highly esteemed right there, in the neighborhood, very, very intentional about her vision, wants the house to remain available for use for her grandchildren for at least, and if they use the house for a dwelling, it can be for no longer than 12 months at a time, after which they have to spelled it out. Other clients, same thing in their trust. Okay, left a commercial property to 2 daughters. They couldn't do anything with it until they reached the age of 25. And then if at the age of 25, they wanted to sell it, they first had to go to the aunt and ask the aunt, on down the line. On down the line. But that's the product of communication and culture. Then you get to that contract, but it has to be intentional.
Excellent. Okay, so we are coming up to the hour right now. And so I don't know if one person has a burning question to ask before we actually do a conclusion and have Brother Isar wrap up, the three C's for us. Anyone has a burning question that has not been asked yet?
Go ahead.
No, I say this was great. I have more questions, but I definitely want to reach out to him for like a consultation, like a one-on-one consultation.
There you go.
Which leads right into my comment was, how do we get in contact with you?
Exactly. That's what I was going to do in the conclusion, which is good. So
Sure.
We brought it up. So Isa, please let our audience know how they can get in contact with you, sir.
Sure. Well, you can reach out to me in whichever way is most convenient for you. I'll give you all the, my phone number, email address, website. Phone number 718-262-0682. That is my number, 718-262-0682. Online, you can Google my name and hopefully it's just me and one other guy with my name that comes up. But my website is just RAHMAN. That's Rahman dash or minus sign ESQ.com. It's Rahman-ESQ.com. And my email follows that. It's just IS like Saturday, A at Rahman-ESQ.com. And yes, I'm happy to hear from all of you on the panel, and anyone else listening. Absolutely happy to hear from you.
Wonderful. Well, I want to thank you so much on behalf of Susan. Would you definitely finish up in conclusion in thanking him so that we can come to a conclusion of this very profitable session?
This was awesome.
Very
Thank you.
valuable. Thank you.
Thank you.
We were taking notes.
No, thank you. And I
Thank you very
definitely want
much.
to thank Winnie for inviting me. And I really want to thank Miss Susan Russell for the vision. This is big, you know, just pulling people together on the platform like this. And at a time, you know, for such a time as this is huge. So I commend and appreciate Miss Russell and the team for this vision. Thank you for including me.
Welcome.
Thank you.
Thank you for coming. Thank you for being a part of our team for today. We really enjoyed it. We all got a lot of information. We were all busy taking notes, and we definitely will get in touch with you.
And I'm
again.
sure we'll all be calling. I definitely need
Yes,
to
indeed.
Yes.
Thank you. And to our audience, we want to thank you. For those of you who are live, make sure that you write your information, notes, and questions so we can forward it on to Mr. Rahman, and that we can continue to have you as our family here in our legacy. And on behalf of our Legacy Plus, we are saying thank you and good day. Bye for now.
Bye.
Bye.